Good afternoon. My name is Max Kramer, and it is my pleasure to defend Chris Donovan on this very important case. The defendant stands here falsely accused of interfering with traffic devices and 3 counts of involuntary manslaughter, all of which are very serious crimes. At the conclusion of the case, we will ask for a verdict of not guilty. Ladies and gentlemen of the jury, this case is about a man accused of a crime he did not commit. More simply, this is a case of mistaken identity. It is our belief that the crime of stealing the wrong way do not enter sign was committed by somebody else. We wish to prove the innocence of our client, Chris Donovan, by proving through facts and witness statements that he could not have committed the crimes. The prosecution hopes that their witnesses will prove our client is guilty of the crimes previously listed. The prosecution hopes to prove that Mr. Donovan was at the scene of the crime and that he committed the crime. However, in fact, the testimonies will show that there is no possible way that our client could have committed this crime and thus caused the deaths of 3 innocent people. Ladies and gentlemen of the jury, the state has claimed that they have an eyewitness who identified our client as the person stealing the sign. This witness is Miss Randy Smith. This supposed eyewitness did not see the person steal the sign, nor could they tell who it was, nor could they actually tell us where they themselves were while they were observing this supposed crime, nor did they actually see the face of the person messing with the sign. In fact, Miss Smith didn't even call the cops when she saw the suspicious activity. Why would she do that? In addition, there are no other witness statements that corroborate Marty Bryant's witness statement. In addition, as our witnesses Ms. Johnson and Ms. Martin will show, Mr. Donovan and Mr. Bryant didn't get along. In fact, Ms. Martin's testimony will also show that the two have gone into arguments before. As per Reese Parker's testimony, he will show that he can only attest to the whereabouts of the sign at 5 o'clock, and as Ms. Martin's testimony will show, the sign was already missing by 5:15. These gaps in the prosecution's argument only go to show that our client is innocent. To be entirely honest, the prosecution's entire argument is weak and fragile. It balances itself on assumed facts and guilt. This is something it should not do because it stops real justice from taking place and it stops people from being able to be productive members of society. Now my client, who is innocent, has to waste his time in court, and the prosecution and state have to take precious resources away from protecting the citizens of the state. Anyways, ladies and gentlemen of the jury, the defense will call 4 witnesses to the stand. Our first witness will be Chris Donovan. Mr. Donovan will testify that he did not go near the 110 exit ramp, nor could he walk there, steal the sign, go to his house, leave it there, change clothes, and then make it to Miss Johnson's house by 8:30. In addition, Mr. Donovan will testify to his whereabouts between the hours of 4:30 and 5:30 p.m. Mr. Donovan will also testify that he found the sign in the bushes by his house and took it indoors, and that is how he came into possession of the sign. Secondly, we will call Alex Johnson to the stand. Ms. Johnson will testify that on the day of the crime, our client, Chris Donovan, was not wearing a burgundy and gold Santa Eleonora University sweatshirt and jeans, and she will testify that Mr. Donovan does not own these clothes. Ms. Johnson will testify that she was with Mr. Donovan on the night in question, and that Mr. Donovan wasn't even near the 110 exit ramp in Santa Eleonora. Ms. Johnson will also testify that our client had lost interest in stealing signs, and thus Ms. Johnson will testify that Mr. Donovan had no motivation to steal said sign. Thirdly, we will call Jesse Martin to the stand to testify on our client's behalf. Ms. Martin's testimony will prove that our client could not have taken the sign between the time of 8:15 and 9:15 p.m. on the 11th of July, as per Mr. Martin's testimony. The sign was already missing on the 11th of July. As per Ms. Martin's testimony, the sign was already missing by 5:15 p.m., a time in which our client was in class and therefore could not have taken the sign. Ms. Martin will also testify to Mr. Donovan's motivation to taking signs. Our last witness is Aaron Grant. Ms. Grant will corroborate what our client testified about finding the sign in the bushes by his house. All of these witness testimonies will show that there is no way that our client, Chris Donovan, is guilty of the crimes listed. Ladies and gentlemen of the jury, we believe in our judicial system. We believe in its ability to find those who are guilty, guilty, and those who are innocent, innocent. At the conclusion of this case, we would ask you to find that our client is innocent. It is the burden of the prosecuting attorney to prove that the defendant is guilty without a doubt, and it's the burden of the state to provide the proof. The state has not met this burden of proof, and we would ask for a verdict of not guilty. Thank you.